This educational program is intended for the personal, non-commercial use of its listener and may not be reproduced for any commercial purpose without the written permission of Rex Crandell and CALDA. The policies, positions, views and opinions expressed and/or provided herein are not those of the State Bar of California, CALDA, or any entity associated therewith, and are strictly those of the authors or speakers. No representations or guarantees of any kind are made with respect to the accuracy of the written, visual, oral or audio portions of this presentation, and nothing herein should be relied upon to answer any legal questions. The written, oral or visual information expressed or provided herein should not be relied upon in dealing with any specific legal matter. No attorney-client or CPA-client relationship is created by any part of this educational program and related activities. Attorneys, CPAs or LDAs using the information expressed and provided herein in dealing with a specific client or clients, and their own legal matters should also research original sources of authority.
Okay. All righty. So I'm going to go ahead and introduce to you Rex Crandell. Rex Crandell is a principal at the law office of Rex L. Crandell. It's an accountancy corporation. Mr. Crandell is an attorney with 14 years of experience. And my document went away real quick. Let me get back to it. Mr. Crandell works in Northern California. I'm sorry. He works in Northern California, and he specializes in estate planning, estate administration, wills, trusts, durable power of attorneys, Advance Health Care Directives, special needs trust, and probate law for individuals and families in the Bay Area. He also has over 40 years of experience in providing extensive income tax preparation. Mr. Crandell, he provides assistance in, he has extensive income tax preparation, consulting and legal guidance to individuals and families, businesses of all sizes, partnerships, corporations, limited liability companies, estate and trust fiduciary tax clients, non-resident alien returns, USA owners of domestic and foreign corporations, domestic and foreign real estate, and disregarded business entities. Additionally, he has experience in real estate transactions since 1979 and has held a California real estate broker license for many years. Over the course of his career, he has represented taxpayers before the IRS, the U.S. Tax Court, the Franchise Tax Board, and Employment Development Department. He is a frequent lecturer to various civic, social, and professional organizations on the topics of income, taxation, financial, and estate planning. And I'll tell you guys what, you are most definitely in for a treat. So I'm gonna lay a couple of foundational things here. If you have any questions about the certification program after this presentation, go ahead and contact the office. You can either email them or give them a telephone call. Also, if you have any questions, please make sure you go ahead and type them again in the Q&A. It makes it a little bit easier. We're going to try to take, it depends on the question, some questions as we go along the way, but for the most part, all of the questions will be held until the end of the presentation. So go ahead, Rex, take it away.
Okay, thank you for that nice introduction. I appreciate that. Let me change the screen over to share my screen. Hopefully everybody can see my screen now that has a estate planning slide on it. I believe that is true.
Yes.
Oh, okay, good. Got confirmation on that. So we're going to be doing two things tonight. First of all, we're going to be talking about an overview of the estate planning process and what are the contents of a comprehensive estate plan. And in addition to that, I'm going to provide information on the Certified Estate Planner certification program that is being offered in combination with our office and CALDA. First off, I'm going to go through the Certified Estate Planner. The way that we have material for you, hopefully you saw in the link that you had a link to our Google Drive where we provided many additional resources for you in terms of forms and information. And I'll explain what is there, but if you didn't download it yet, it's still there for you. So we came up with the Certified Estate Planner to try to improve the estate planning process all through the state and give people information on how to do estate planning, get the confidence of doing the estate planning and experience if they hadn't done them before. Some people have done them for years. Other people are just getting into the activity, and it's quite helpful if somebody's learning this to do their own estate plan for family members or others. And the way the class is going to be presented is we have 8 classes with different subjects, and there's reading and homework assignments. The class is given on a credit, no credit basis. It's not a letter grade. And after each class, you'll have homework. And as part of each subject matter that we go through in the 8 classes, you will have to prepare estate planning documents and turn them in for credit. And so that's how you're going to be doing the estate plan, is in pieces. So the certification will be provided to you after all the homework has been turned in and you pass the final exam. And there's also a CALDA professional estate planning badge. The materials will be provided to you in the Google Drive. And I've written a book on estate planning, and I'm going to provide a chapter of that book every class. And then the other book that you'll need to buy is Nolo Press, California, I don't know if you can see that, Estate Planning Guide by Nolo. And we have assignments indicated for both books and questions at the end of each chapter. The course outline tonight is the overview of the class, and the next class will be wills and trusts. And so the structure of the course, you watch the video or the webinar and you read chapter 3 example in my book, and the pages to read in the Nolo book will have multiple choice questions at the end of each chapter. And I want to make it clear that when you turn in your homework, do not send it to CALDA. You'll have my email and contact information, so all homework goes to me and not to CALDA. So you submit the answer sheet, and then in each of these classes, you'll have an assignment, a document. So in this class, you have to prepare a complete will, witness, signed, and turn it in for credit, no credit. If it looks like a will and it seems to have all the components, you'll get credit. If it seems to be lacking, it might be sent back to you for improvement. And you're not going to be getting a letter grade in this class. It is credit, no credit. And so you have wide latitude on the documents that you actually prepare. Then the next class, we have trusts broken out into 2 different classes because trust is so prevalent in estate planning that we broke it down into parts. Then we're going to cover the durable power of attorney for asset management. You'll turn in one of those. And then we'll talk about the Advance Health Care Directive and end of life decisions. We have a section on probate. However, there is no class on it. This is on home study. and you have to prepare the initial filing forms that you would need for a probate. Then we're going to cover income tax for estates and trusts. And the objective here is not to make you an income tax preparer, but the idea is that you have an exposure and you know what the landscape is like for the wills, trusts, and estates and how they work. And because there's some really unique tricks within the fiduciary income tax returns for estates and trusts. The next class, we're going to be covering real property taxation, which is huge and very important. We'll cover that in detail, including the parent-child exclusion. And then we're going to have just an overview of the estate and inheritance tax. We're not going to spend too much time on it because only about 2% of the decedents in the United States are required to file the inheritance tax return. And then we have a final exam, multiple choice, you need to get 70%. So if you've not already bought the book from Amazon, California Estate Planning, there's a link in our resources. And we're not giving you, you have to figure out on your own how you're going to prepare these documents that we're requesting. So you have complete latitude. You can use a friend's software, you can buy your own. There are several statutory forms, and these resources are just to give you an idea of how you might want to prepare the documents that are part of the homework for this class. NOLO, Quicken, Willmaker, and Trust, it's pretty good. We've used it. It's adequate, does a fairly good job, has a lot of extra forms are included, and it's reasonably priced. For Trust, now we're getting into some money and cost. That's the software our office is using presently, and depending on what deal you work with them, maybe $1,200 to start, maybe yearly. I can't quote prices for anybody accurately. And then For Trust is trying to force people into the cloud, and they have another software that they call Adapt. So, and they're trying to make that more affordable. And this is a software I used to use, LexisNexis, California Wills and Trusts. And it's very good, very detailed, been around forever, has a great reputation. One of the things that I noticed with California Wills and Trusts is comparing it to For Trust. For Trust, you can prepare estate planning documents for any state in the nation. In California Wills and Trusts, all their documents are good documents, and they're all California. The other link that we're giving you here is for the California statutory forms. You can use those for your homework assignment too. They're basically, this legislature got together and say, if someone doesn't have, let's say, a will or durable power of attorney, that they can use these forms and they can get by with those. So let's get into the technical part. The learning objectives for the class is to understand why a comprehensive estate plan is needed. We get people in our office, they come in, I need a trust, or I need a will. And I go, well, we need to talk about that. There may be some other things you are unaware of. And usually we have 4 legal documents in what we call a comprehensive estate plan. And then later in the class, we're going to cover several situations where famous people have really caused problems in their own estate plan. So this is kind of a definition of what I call a comprehensive estate plan. It's not required by anybody. There's no law that says you have to use that word, but it's what we use. So we generally do 1 revocable trust per couple. We can do others, and trusts can have other sub-trusts. We do 2 pour over wills if they have a trust, and that the wills pour back or direct the assets back to the trust. And we do 1 for each partner. The durable power of attorney for asset management, we do one for each spouse, and the Advanced Health Care Directives, one for each spouse. So my saying is comprehensive estate plannings, don't leave Earth without it. So why do you need an estate plan? If you own a house in California, you likely need a trust. And I try not to oversell trust because there are some benefits to having a will, and I'll cover those. But in general, the number that you need to memorize right off is if you have the fair market value of assets in a person's estate is greater than 184,500, then you're looking at probate. And that 184,000 is not all inclusive of all assets that a person might have, because there are certain contractual assets that are not included, like pension plans. They have a beneficiary statement and a contract with the pension administrator. Life insurance, annuities, IRAs, they're all not included in that number where you're going to need a probate or not. So if somebody doesn't have a will or trust, which happens quite frequently, then the state of California gets to decide on who gets your assets. And it may not be the same plan that you had envisioned. Okay, what we kind of use the terminology centerpiece for an estate plan. And if you're using a trust as a centerpiece, then you end up with a certain group of forms. But the number one advantage that everybody talks about for a trust is it does in fact avoid probate. And the beneficiaries can get their bequest faster than with a probate and with less court fees and paperwork. The person who creates the trust runs their trust, manages it however they want while they're alive. And after they pass away, then the successor trustee takes over and pays all the debts and distributes the assets, complies with any tax laws or any other requirements. So in a declaration of trust, that's basically you're saying, I am creating a trust. It is less frustrating to do. We do estate administration and probates, and it is less paperwork. And although, there's fees related to probate, I don't think that it's a good idea. And I would not advocate that everybody go into probate except in certain circumstances. And it also, when you make someone a successor trustee, you may not realize it, but you're putting a burden on them. And I work with a lot of trustees who've never done it before. And when they get done, they say, my God, if I would have known it was this much work, I would have never been a trustee. Not only that, beneficiaries can be really mean and demanding. We have a little joke in our office that the beneficiaries have a song that they sing to the trustee or the executor. Where's my money? Where's my money? I don't care if you have things to do. I don't care if there's laws. Where's my money? And it sounds funny, but it happens more frequently than you would think. So the flow of the documents, you create a trust. And in order for the trust to control the assets, it has to be titled in the name of the trust. And then you will have a backup will. And then after the administration, then the distribution of the assets to your heirs. I use the example comparing a trust to putting your assets in one of these pod containerized cargo things. So by titling the assets in the name of the trust, you're kind of like putting the assets in this pod. And if you want to use the assets in your front yard, go get it. You still do whatever you want with it. And then after you die, they close the door on the pot, lock it, and ship it off. And your assets go for a ride called estate administration to your beneficiaries. And then their assets are delivered to the beneficiaries, and it ends up being a problem. There's usually several assets that are left out of the trust inadvertently. But it's a good analogy that if your assets are not labeled into your trust, the trustee cannot manage those assets for you. It's like a corporation, that a president of a corporation can manage all the assets in the corporation. But if it's not labeled in the name of the corporation, they can't do anything. They have absolutely no rights to it. Okay, so if you do have a trust, then you have another document that's usually rather perfunctory. It may be only 8 pages, and it's called a pour-over will. And what this says, if I have assets that are out of my trust, go put it in the trust. If my trust is invalid for any reason and you want to know what to do with my stuff, read the trust and do it. And so every time we don't put dispositive or beneficiary designations in a pour-over will, we just point everything back to the trust. And when somebody passes away with assets over 184,500, we're doing probate. Another thing to keep in mind is that under California law, when somebody dies, the original will must be lodged, filed, and paid the filing fee of about $50 with the Superior Court in the county of residence. And that does not matter if you're doing a probate, you're not doing a probate. The law says if somebody dies, you must file that will with the Superior Court. Okay, so I think oftentimes people oversell the trust, and I'll try to be more balanced in the presentation. So some of the detriments of probate, essentially the purpose of a probate is to get a signature from a dead person, but the legislature, their view, and it's good, is that they want to prevent fraud in assets. So they get court supervision and the judge signs off before anybody gets any distributions. It is expensive. We're going to cover the fees here in a moment. And I point out, because it's often misquoted, when you hear somebody talking about the probate fees, it's not statutory and people misconstrue it. It's the maximum. You can negotiate less. It doesn't have to be that amount. And the attorney representing the estate, if there is an attorney in that probate, gets the same dollar amount as the administrator executor gets, unless the executor waives the fee. This next item, the liability aspect, is one of the great good reasons to do a probate, and that is limitation of liability. So let's say you have assets, maybe different kind of potential claims. Let's use a hypothetical. Someone's a gynecologist doctor and they have potential claims that are going to last for years. If they do a probate, when the judge issues that final distribution order, all creditor claims are done. They're cut off. And that helps two people, or two groups of people. One is a trustee and the other is the beneficiary, because sometimes there is transfer liability for the assets being transferred that go to the beneficiary and the debts hadn't been paid on it. But it's something to keep in mind. Liability for the trustee gets cut off from creditors and other claimants for the beneficiaries. Another benefit of a probate, you can do it either as a regular probate, or sometimes they have what's called a testamentary trust. A will is created and it says, when I die, go to the court and I want the judge to create a trust that says this, that, all the way through the details. And there are times when that's a good idea. For example, one case that I saw was a woman who had a young son, and she owned an apartment complex, and she wanted court supervision to make sure that those assets were there because she didn't have any direct family members to be able to be the trustee. And so the court ended up supervising. Now, what does a probate cost? In our example here, if you have a $2 million estate, and that's fair market value, the first $100,000, the fees for the attorney and the executor are 4%. Next $100,000 is 3%. Next $800,000, it's 2% on down the line. Now, if you want to know how much it's going to cost in probate fees, there are a number of online probate calendar calculators. Just do a search for probate calculator, and there are many of them out there. You just put in the dollar amount and you'll see how much the estimated fee. So in this example on 2 million, the attorney fee would be maximum of 33,000, and then the executor or administrator would also have the right to that amount of compensation for the work that they did. However, most of the time in my office, the executor administrator waives all fees. And the reason is, if they're going to be inheriting most of the assets, then those assets are not taxed when they are received. But if they take a fee for being the executor, then it ends up being taxable income. So in addition to what they say is the maximum in everything in law, well, there's exceptions. So even with this fee structure that seems high, there are additional fees that might be charged. They're called extraordinary items. So if they're selling of real property or selling a business, litigation claims, either prosecution or defense litigation, or distribution of unusually complex assets, then the administrator and the attorney can ask for additional extraordinary fees, and if it's reasonable, the judge will grant it. In a probate, nobody gets a nickel of compensation, whether they're the attorney or the administrator, until the final distribution order, and then the judge decides. If the judge says they think that the fee is too high for some item, the judge just cuts it, makes it, and that's what it ends up being. The judge is in charge of final approval. Okay, next document is a durable power of attorney for asset management. It's not just a regular power of attorney that you would give someone, and the term durable means that it is still effective if somebody becomes mentally incapacitated or mentally disabled. A regular power of attorney is void at that point. So in this case, what you're preparing to go against to avoid a problem is you become mentally disabled, and now what? How are you going to manage your assets? You try to deal with banks or third parties, and they say, who are you? You can't manage someone else's asset. They say, well, they're mentally incapacitated. So it's not the bank's problem or any other vendor. And what happens if you do not have a durable power of attorney for asset management, and assets are not titled in the name of your trust, which means ultimately your will control. So assets not in the trust are managed by the agent or the attorney, in fact, under your durable power of attorney for asset management. So what happens, the flow of documents, if somebody becomes mentally disabled, first of all, in their trust, they're no longer allowed to be a trustee, so they're kicked off, not kicked off, but removed, and a successor takes over. And for other assets that are not in the trust, then the durable power of attorney for asset management comes into play, and that person can manage all the assets. A third document that is used to protect against mental disability is the Advance Health Care Directive. So doctors have very steep penalties if they give out any medical information about any patient without the patient's approval. So even a spouse, or, you know, you would think would have authority to get medical information, they're not going to get it. So the Advanced Healthcare Directive gives the medical provider authority to talk to a third person. And oftentimes we'll have the Advanced Healthcare Directive, most of the time, be effective on signing rather than just if they're incapacitated. On the durable power of attorney for asset management, we generally make them effective when somebody's incapacitated, otherwise it has no impact. And that term is called a springing durable power of attorney. Other people will create these documents, this durable power of attorney, and make it effective immediately. The problem with that is if the agent steals assets from your estate and you call the police are going to say, hey, you gave them authority to sign on your account. It's your problem. They're not going to help you. So on the Advanced Healthcare Directive, we need one for husband, one for wife, and it includes the end of life decisions usually. There are other forms that we're going to cover in more detail later. One is called a POST, Physician's Order for Life-Sustaining Treatment. This one, you can't prepare it. A doctor has to sign, make this one effective. And it basically says, if I have a seizure and I'm in my house and they call 911 and the fire department comes out, there's an orange paper on the refrigerator that says, hey, rescue personnel, don't give me CPR. I don't want it. And the same thing with a do not resuscitate order. So there are times when somebody does nothing, no estate plan, and what happens with some assets. If you're on joint tenancy, very bad to do. I don't advocate it at all, but the survivor takes and gets control of the entire property on death. We hear people saying it's kind of like a poor man's estate plan where they put a son and daughter on title. Bad idea. What happens if the son or daughter gets a multi-million-dollar judgment against them and then the creditors come and take mom's house? Another problem without an estate plan is when there are children from previous marriages, it causes some problems. So what happens if a person writes their own will? It's legal in California. It's called a holographic will. The first question is it valid? And what happens if there's real estate? Well, the answer is probate. What if the person changes their mind? You can do that. And there are also sometimes comes up a question whether the person was unduly influenced. Like say that people have 5 kids and then one person's taking care of grandma, and then all of a sudden that one beneficiary gets all the assets and the other 4 are cut out. Kind of sounds like undue influence. Another way to do estate planning is what I call the vending machine method. And you go to the internet, you pay a few bucks, you download some forms, and you fill them out. Good luck. We've seen some really bad ones, and we've had to come in and straighten them out. The problem with it is it's not customized to your individual wishes. So it's like you went into a clothing store, you wanted some new clothes, and you go into the store and say, I want one size fits all for all my clothes, like oversized or something. You're not going to be happy with it. And that's the same thing with the downloadable forms that you pay for on some of these online sites. Maybe they've gotten better, but we've seen some really problems created with them. So it's better to look around and find somebody who's experienced, that understands what's required to make the estate plan work for you. Oftentimes we have clients come in and they say, I want to do this and that. And I go, okay, it's not going to work, but I'll tell you an alternate way that will work. So we have to work around to make it come out the way that they want. So just a definitional question, what's a comprehensive estate plan? It is 4 documents: revocable trust, pour over will, durable power of attorney for asset management, and an advanced health care directive. Okay, so in the material that we've provided you, on the link for the material, I have tried to include things that might be useful for you in doing estate planning, either for yourself or others. The first one that I'm going to refer to is an estate planning organizer. And I want to thank Jim Wilroy for his assistance on this one. So this is an organizer for a couple. And the purpose of an estate planning organizer, even if you're doing your own, is to get everything in one place so that you cover all the bases. One thing that's huge is if somebody's not a U.S. citizen and they inherit property. We'll get into it later on the inheritance tax problems. And listing of the contact information, and whether husband and wife want the same distribution plans. We have clients that the husband wants one distribution plan if he dies first, and the wife wants a different distribution plan if she dies first. Fine. And listing children from previous marriages, we have procedures to help facilitate that, to protect assets from the surviving spouse getting remarried and the new spouse takes all the money from the previous marriage children. So I do recommend filling these out, even if you're doing your own estate plan, to kind of think things through. And one thing that's really important, and we have these lists, we always use a factor of 3. So like on a trust, for example, husband and wife, or the survivor is going to be the trustee. But when the surviving spouse dies, then we need backup. And we've had trusts where the successor trustee has died. And now there's no trustee, and the document gives no method to appoint another trustee. So what do we have to do? We have to go to court to get the judge to say, yes, Uncle Bob can be the successor trustee. So I always insist clients give me 3 alternate successor trustees. And if there are none, that happens. There are licensed professional fiduciaries who are professional trustees that can do that. And then for the durable power of attorney for asset management, the successors are generally the same as for the trusts. However, the Advance Health Care Directive, oftentimes, well, not too infrequently, there might be different successors, agents for the Advanced Health Care Directive, because perhaps 1 or 2 of the family members have a medical background, or they're much more in tune to making decisions like that. And one of the problems, you want to have somebody who has a little bit of backbone, because if you have an end of life situation where you say, if I'm comatose for 3 weeks, go ahead and pull the plug. If the person can't do that, and that's your wishes, that's what you want, then that's not the right person to name as your healthcare proxy. Now, a real important point for wills is people with minor children. If both spouses have died, then the child needs a guardian, and somebody has to step up, go to court to become a guardian. And in a will is the only place that you can nominate guardians to take care of your minor children until they become of age. And I say nominate because it is in fact a nomination, and it doesn't happen until the judge says that they're the guardian, because there's background checks that if they don't pass, they're not going to be the guardian. So anybody with minor children at minimum needs to have a will to appoint guardians. And then we think, go through some of the things you might want to think about for end of life decisions and distribution of your remains. And this organizer has a place to list assets, and it's good to use it. We have another form that I'll get to in a minute where it's a lot more detailed. So let me, okay. Oh. Okay, we have another estate planning organizer material for single people. So whether it's a couple or single, we have those forms for your use. Now, we've included another form that is a much more detailed asset list. If they have a lot of assets or complex things, this form could be used, and it is set up to help identify what the character of some of these assets are. And I've included footnotes on definitional things. Let me show you here. So is it held as separate property? Is it community property? Is it joint tenancy? How are you holding it now? Oftentimes people think it's one way, and then we pull the deed on their house and we find out it's in a different method. So the column here, you can, if you identify how it's held. Percentage owned, you might own 50% of a business, so you put a 50%. And then is it a probate or non-probate assets? We've included the definition of what non-probate assets are. Usually it's pensions, life insurance, annuities, and things with a contract with the vendor. And then what is approximate fair market value that you're talking about, the value of that asset. And then this column we made to be able to use to determine and organize yourself. Did the asset get labeled in the name of the trust? Yes or no? Funding a trust is really important. We've seen people that have had a trust, they've spent good money creating a trust, and they didn't transfer any assets. Well, the trust is worth less than the value of the paper if it was blank. It does absolutely nothing. So you need to make sure that you stress that anyone who has a trust funds it with titling the assets. And we don't let an estate plan go out of our office unless we actually record the real property in the name of the trust. We won't let a client do it because it's too important. So you have this form for your toolbox. Okay, another document that we're providing you in your course materials is a estate planning workflow checklist. And this is as you're going through the estate plan, you might do 2 or 3 things in 1 week and then stop, and then 2 or 3 weeks later continue on. And this kind of lets you know what you've done and the workflow, so that all the things get done. And after you've tried to do your own estate plan, and after 8 weeks or 8 months, you might not remember, did I do this? Did I do that? And if you're doing a high volume of estate plans, you may not remember either. So you need to have something that will spur your memory that those items have been completed. Okay, how to mess up an estate plan. We don't recommend it, but it happens. So here's some examples. Abraham Lincoln died without a will. Other people died without a will, Sonny Bono, Picasso. Most young people don't have a will, but if they don't have many assets, a simple will, even the statutory form, will work well for them. Martin Luther King Jr. died in '68, and then after he died, his beneficiaries were fighting over his assets for years. Jimi Hendrix died at the age of 27, and his dad took over because there was no will, and he had about $80 million, and his dad, Al, ended up giving the estate to an adopted daughter instead of Jimmy's natural brother, Leon. So it's quite likely that Jimmy would have wanted a different distribution plan. Another example is Supreme Court Justice Warren Burger did a really cryptic estate plan, and even though he had the resources, he messed it up and caused an estate tax liability. B.B. King is another example of court fights after death for a long, long time. There is a clause, you'll hear about it, it's called a no contest clause. And a few years ago, the statute weakened that clause so that certain types of claims can still be litigated. And what the no contest clause says, if you challenge this trust, you will be treated as you've predeceased the trust maker or the will maker. And so, and you died without heirs, without issue. So what it does, by saying that, it cuts out the person who disputes the estate plan. However, there's a lot of trust and estate and probate litigation that, and the majority of it that I see, the no contest clause is not applicable. Another problem that's fairly common is you have longtime partners, they're not married, and when one dies, the other one has no rights. So we had an example where there was a long-time partnership, and one of the spouses died, or partners, and he was the one that owned the house. And then the wife, who had lived there for umpteen years, the police wouldn't even let her in to get her toothbrush or get her clothes back out. And so you need, if you have a long-term relationship, more and more people are not getting married, you need to do estate planning to make that more favorable for your spouse. So listing here several people that never got married. This was an example of bad estate planning. The Wrigley family, they own Catalina Island, or the Conservancy does, and they ended up with a huge tax dispute, multi-state and IRS, and they ended up having to sell their sports team, Chicago Cubs, and they only got, in 1981, $20 million. And then later in 2015, Forbes said now it's worth $1.8 billion. So this mistake had a value of about $1.5 billion. mistake. It's like, oops, don't want that to happen. Michael Jackson's estate, litigated by the IRS. They finally made a settlement, but he had a significant amount of income coming to his estate that he didn't plan properly. So he got the assets had a huge fiduciary income tax that could have been avoided with proper planning. Conservatorships. If you have a choice between a durable power of attorney and asset management or a conservatorship, there's no question. You don't want a conservatorship. When you're filing a new conservatorship, the stack of papers is unbelievable. And it's really sad times when, let's say, dad becomes mentally disabled and there's no documents in place. Now, in addition to having all the care problems and all the emotional setback and everything, then you go to the court and you say, I need a conservatorship, and they give you a stack of papers. It's unbelievable. And you have to have it picky, line by line, correct. And it seems like excessive for these people who have family members that can't care for themselves. So there are other problems. We had one example where this gentleman had two children, son and daughter, and his will and his trust, everything wanted to have it split equally. Well, the son was helping him out, and he said, gee, Dad, you should put me on as joint tenants on the house so I can take care of everything and give half to sister, and joint tenants on the bank accounts. And then when he died, guess what? The daughter got nothing because the survivor owns everything on joint tenancy. One problem that is fairly frequent, that someone will do the right thing and they'll put their house in their trust. Then they go and refinance their house. And the bank makes them take the title of the house into their personal name before they'll lend them the money. Then what happens is the person forgets to put the house back in the trust. Guess what? Now the house has to go to court, either on a probate or there's a separate procedure has to do with called the Hegstad petition. And that way you have to ask the judge, say, was the asset was listed on our Schedule A in our trust. We intended it to be in the trust, or they did before they died. And then the judge will, not always, but this procedure exists, will order that the house be put back in the trust and a probate avoided. Problems with trustees. If you have a probate, the probate court's going to require a fidelity bond. If anybody steals money from the probate estate, the bonding company makes good and reimburses the estate for the stolen money, then goes after the culprit. In trusts, they're not used. And we've seen horrendous problems of dishonest trustees. The parents thought that they were honest. They got a hold of the money and it just burned a hole in their hand and they just took everything. So what I recommend people consider is having a fidelity bond, even if it's relatively small, to force protection of the assets before a person can become a trustee. Then when they do a background check, if they can't get a bond, the trust can be written so that they can't be trustee. Well, that's good. Another problem to avoid is having multiple trustees. It can be a disaster. If there's more than one trustee, every decision must be unanimous. So you end up with a lot of conflict when there are co-trustees involved. We don't like to do that at all. So incapacity, we've already talked about that, how the Durable Power of Attorney and Advance Health Care Directive take over. and try to do a good estate plan, and you will make your beneficiaries a lot more appreciative that you took the time to do that. So I'd like to open it up for questions if there are questions.
Okay, yes, there are. We do have a few questions here. Let's go over a few of these. Which book, which NOLO book are we going to be using?
Okay, it's in the course outline, and the exact title is Every Californian's Guide to Estate Planning. Subtitle is Wills, Trusts, and Everything Else. So when you're doing estate planning, and virtually most kinds of law that we do other than federal income tax, if it doesn't say the word California in it, I won't buy it. Because if you get somebody writing about estate planning and they live in New York, guess what? California law is extensive. And anyway, that's the answer. The California Guide to Estate Planning, and the author is Liza Hanks.
Liza Hanks. Okay,
Yeah.
and will you be including some of the samples of documents to look at in the classes? Just kind of a brief overview of what the class will look like.
Okay, the documents, the answer is no. We are not including model documents, but if you recall in the course outline, I gave you links so you could locate the statutory forms. So that would be some that you could look at. You could also go to the law library. I've given you resources. A good low-cost way to do it is buy NOLO's Will and Trust Maker, $200, and you just make all your forms. But I'm leaving that up to the students to, you figure it out. How are you going to do this? You're going to use statutory forms? You're going to take somebody else and retype it? It's your problem. You just need to turn it in with the homework. But it would be too much paper. I was doing an estate planning signing today, and the stack of documents was this thick. And we're not going to provide that kind of overkill in paper in the class.
Okay. And a couple of questions about, I want to stay on point with the classes. So we answered the question on what the NOLA book is. Do you have to itemize items in a pour over will or a will and testament? Oops.
Okay, so what we're talking about here is an itemized list, and what that implies is you want different assets to go different places. You want certain conditions, you want this done, that done. The answer is you do not put it in a pour over will. The only purpose of a pour over will is say, you want to know what I want done with my stuff? Read my trust. If my trust is invalid and you don't know what to do what the trust says. So any question that comes up points back to the trust. So no details except that directing it back to the trust, and also the nomination of guardians for minor children.
Okay, and then someone wants to know when the no contest clause will not work. What circumstances could the trust be challenged?
There are many, just off the top of my head. If there's allegations of trustee misconduct, the most frequent one that I see is the beneficiary demands an accounting and the trustee doesn't give it to them, and they go to court to remove the trustee and order an accounting. There's a thing called breach of fiduciary duty. A fiduciary, a trustee, or an executor must be impartial for all beneficiaries. They can't favor one over the other. Everything has to be unbiased and equal for all the beneficiaries. So a lot of the complaints or litigation over trusts and state administration have to do with claims of breach of fiduciary duty And if you want to know more about what those duties are, do a Google search for California fiduciary duties, and you'll see there's a whole bunch of them.
Okay. And then something about the course. Will this course be offered again in the future? And one individual will have to miss the next course. Can that course be made up?
Okay, so this series of classes is going to be recorded and available on CalDA's website. So there's no problem at all. I mean, even if somebody didn't go today and they came tomorrow, next class on wills, they could go to CalDA, watch the first class online, sign an affidavit that they attended the class, get all the course outline and materials, and they can continue on. So it's absolutely no problem missing a class and making it up. And the other part that's going to happen with this course is after all of the 8 classes have been presented, we're going to package the entire estate planning certification program into software where somebody can just start anytime on demand and do the whole class.
Okay,
so,
great.
Yes, it will be available for a long time.
And I think you answered this question, but the question here is, do you recommend that we help them fully fund the trust, not just real property assets?
Okay, it depends on who you're working with and what if you're getting paid for the service or whatever. It is a good service for people who prepare estate plans to offer at additional charge to do all the funding. In our office, when someone says, you know, we'll help you do the funding, and they say, your law office, that's going to cost a bunch. No thanks, is what we hear. But you can offer packages, do certain forms. It's something good to have a discussion about. There are classes available where somebody can learn how to fund all kinds of assets, but it should be a discussion, and it should be emphasized to the people receiving the estate plan. And we not only emphasize it verbally, but we also include information on funding in our finished product and how to title. So when you title it and how are you going to sign, it's going to be My Fantastic Trust by Rex Crandell Trustee. So funding is a huge thing that needs to be emphasized. Yes, it can be a service you could provide.
Okay, great. And another question, in California, do you find it difficult to have a doctor sign off for the durable power of attorney?
What happens in practice, it depends who it is and which medical provider, but I don't find it that difficult. I mean, there's some other options. You can not name a doctor. You could name another person, you know, Uncle Joe. If Uncle Joe signs a paper and says, I'm incompetent, okay, you don't have to have a doctor. It's just, it becomes impartial. There are times, I saw a case recently where we needed to have one for a conservatorship, and Kaiser was dragging their feet. It normally does not happen that way. So yes, it could be a problem, but who knows? You know, the other way is you can have someone else make that decision.
Okay, great. We have about, let's give ourselves to about 7:15, you guys. So if there are any other questions, please go ahead and type them in the Q&A related to the revocable trust, or related to the trust, as well as to the course. There was put on the screen, and Rex, maybe you can pull that up right now again, the schedule. So the dates of the courses, and you have a really nice explanation of what you will be going over in those courses.
Okay, so I'll bring it up in a second here. Okay, so The dates are in your handout material online. And so it shows here, this is the dates that we're going to have one a month. I believe it's the 4th Thursday of every month. So it's in your material. It'll also be available from CalDA.
Okay, so let me stop right there, scrolling down, scroll up a little bit more. So as you guys can see, you know, each class has the class, the name of the class and the class date, and then what will be required during that that class. I think that was some of the questions that I had.
We've given very specific homework instructions designed to make people become aware of the different types of forms and transactions that are customary. It's not to make you an expert on all the pieces of, like, say, probate or income tax, but at least you have a working knowledge and the vocabulary and some idea of what the circumstances are. Okay.
And I have a few others. Can we get copies of the slides? Will we be getting copies of your slides?
I believe I put them in the cloud on that link to Google Drive.
Okay, so you guys make sure.
I believe I did put it in your link, but I've got so many files and I'm adding so many things to the class all the time. If it's not on your link of class materials, let me know and I'll make it happen. But okay. I think the answer is yes. I have so many forms, I can't remember which one's which. I mean, where they are.
Okay, and I think he did answer the question, you guys, about which edition the NOLA book is. Which edition is that? Real quick, Rex?
My book says the 2nd edition.
Okay.
But it's not that important because I've got the 1st edition too, and they did not change very much. They did not update it as well as I thought they would have.
Okay.
And also, in terms you were asking about forms and stuff, the NOLA book gives you a link to NOLA where they have different kind of forms for estate planning concepts.
Okay. All right, you guys, we are at a few more minutes, and I want to just say that I know some of the questions in here were related work specific questions, so those aren't you know, I want you guys to make sure that all of your questions are being answered, but we just want to make sure that we start this program out right. And he gave you guys so much information tonight. If you're new to estate planning, or if it's something that you're interested in getting into, I would highly recommend that you make this a priority, because trust and believe he will give you more than what you would get anywhere else. And he is very accessible as well. You can pick up the phone and give him a call, and he can help you out. Okay.
And I wanted to make a comment. Many years ago, the first estate planning class that I took with the California CPA Society, I was there 8 hours and I did not understand anything when I started. And it took a while to get this knowledge. But my point here is you're going to have access to the videos after the class is over. So what I recommend people, if they're, to learn more, is go back and play it a second time. Listen to it a third time. Record it on audio on your phone, and the repetition really helps burn it into your mind and learning. So take advantage of the repetition ability.
Absolutely. Absolutely. So you guys, some of you are asking about the program and where to send the homework. Once you enroll, you will get all of that information that you need. Okay. I see some people screaming at me. Can someone answer my questions? Okay, so I'm going back up the screen here.
I want to answer something about the homework. In the multiple choice questions, we've included an answer sheet that you can copy and paste or take a picture on your phone and send it in to us. Send all homework to me and not to Calda, but the answer sheet and where to send it is part of your materials.
Okay. There was also someone that says they're not a member. So this certificate, this program is only for CALDA members. So you have to be a member of CALDA to, that's one of the requirements to be able to take the program. Okay. And so here's some.
I might comment on that. That's assuming that the person is an LDA and you know, is a member of CALDA, and I'm all for that. But on the other hand, there are some people who want to take this, and they can contact me about it, is they're not a professional, they're not a paralegal, they don't have a legal background, but they want the certificate, and they could talk to me about it and we could discuss it.
Okay. And then one more trust question here. How is separate property handled in a trust for couples? Should two trusts be created instead?
The answer to creating two trusts for separate property is no, don't do it. The way the law works is if you have separate or community property, what we do, let's say, well, when you transfer property into a trust, and let's say it's revocable and you take a property back out, if it's separate property going in, it's separate property going out. If it's community property going in, it's community property going out. So, and then the other part that we do is we have a separate schedule for all the assets, Schedule A, in the back of a trust, but we also have another schedule that says one spouse's separate property is this, this, and this. The other spouse's separate property is this, this, and this. So it's all encompassed in one trust.
Okay, you guys, we are at 7:16. Thank you guys so much. If you guys are members and if there are questions that you have, please feel free to go to the members forum and you can post any questions in there. But I want to thank you guys. Rex, you have, as always, have been, you know, I'm sitting taking notes myself and like, oh, I didn't know that, but now I know. So thank you so much. Awesome job. And I look forward to the next one.
Yeah, I'm happy to help and I enjoy teaching classes. So
awesome.
See you next time.
Have a great evening, everyone. Bye-bye.
Bye.